In the complex litigation system, disputes over electronic evidence are considered especially heinous. These disputes are resolved by two separate yet equally important groups: the technologists who investigate the data and the attorneys who argue the merits in court. In electronic discovery, the dedicated consultants who analyze and investigate the data are an elite team known as the project advisors. These are their stories.
Hello, everyone, and welcome to our first edition of the Law and Order Discovery to Dispute Unit, Episode 1, the Plaintiff Movement. This is going to be Dixon versus Lockhart Canning Company. For those of you who I have not had the pleasure of meeting, my name is Jeff Hudson, and I'm the Director of Professional Services here at Acorn Legal Solutions. I'm going to be playing the role of judge today. Highly unlikely, but I will be. I'm joined by two of my esteemed colleagues who are going to be assisting today. Representing the plaintiff will be Chad Roberts. Chad is the founder of eDiscovery Co-Counsel. He is a former litigator, trial attorney, and now focuses on discovery practice, information governance, analytics, information retrieval, etc., in the eDiscovery space. And then representing our defendants today is Amanda Cook, who is a senior project advisor here at Acorn as well. In addition to also being an attorney, Amanda is an eDiscovery expert who is also a relativity certified admin and also has the SEDS credentials, and a number of other things related to eDiscovery expertise. So we'll go ahead and get started. So I wanted to give a quick summary of the facts here today. If you have not had a chance to look at the broader summary of the facts, I just wanted to loop everyone in here. We have our plaintiff, Brandon Dixon. He's an African-American male who was recently terminated from his employment at Lockhart Canning Company, who is our defendant. After termination, Mr. Dixon filed a lawsuit against LCC alleging that his termination was based upon his race and made claims of discrimination related thereto. He also, in conjunction with filing his lawsuit, had a press conference with his attorney present, at which time they made some allegations about Lockhart Canning having a history of the discrimination, particularly related to their retired founder and CEO, Dylan Sweeney. As a result of some of the comments made during that press conference, a counterclaim for defamation was filed by Lockhart against Dixon. During the course of this litigation, we've had some discovery disputes in which the defendants have requested that all of the plaintiff's mobile devices, personal and any other, be handed over for copy and inspection by the defendant. And we have also had an issue with Mr. Sweeney's email either being lost or deleted due to a change in data vendors that LCC undertook during the process of this that was unrelated necessarily to this case. The plaintiff has filed a motion for sanctions related to the lost or deleted emails. That will be addressed at another time. After we address the current issues before the court. The defendant has filed a motion to compel the production of the plaintiff's cell phone. They've also filed a motion to dismiss their claim for defamation, which in substance is a leave to amend their counterclaim in which to dismiss that cause. The plaintiff objects to both motions, the motion to compel, as well as the motion to dismiss the claim against him. So the issues that we are looking to decide today are these: should the plaintiff be compelled to produce all cell phones or personal devices for copy and inspection as requested by the defendant. And should the defendant's motion to dismiss the defamation counterclaim against the plaintiff be granted despite the plaintiff's objection to that dismissal. And with that, we will hear from Mr. Roberts and the plaintiff first. Mr. Roberts will give you about 5 minutes.
Thank you, Your Honor. And if you want to do it, we'll reserve any time, seeing as it's the defendant's motion at issue here. Thanks. And let me take the issue up in just the inverse order in which you described it, because they're linked and connected and as you can see, interrelated. When they filed a counterclaim against Mr. Dixon for defamation, they did that subject to Rule 11, which is that they conducted a reasonable investigation of the facts before they filed and signed their names to that pleading under Rule 11. And they also did it subject to Rule 1, which is a directive in the rules, the first rule, which is we will not gratuitously waste one another's money and or the money of the time of the court or the treasure or money of any of the parties just gratuitously. If they were concerned that the truth would not be, we all know that truth is a defense to defamation, and it puts at issue the truth of what we've said. So now that discovery is encroaching on that truth and getting to that truth, they would like for this all to just go away by dismissing their claim and basically saying, never mind, forget about it. We'll just go away and hope that it'll all be in the rearview mirror. They've wasted an enormous sum of Mr. Dixon's money and his effort and increased his costs just gratuitously to do that. This related discovery request now for his cell phone is just a retaliatory gesture for our opposition to the dismissal so that you can hear both issues at once and understand how they're related. Mr. Dixon's cell phone itself, as a cell phone, is not at issue in the case. There may be information in his cell phone that is responsive to some Rule 34 request, but a request to get his cell phone and just run amok on it and traipse through it for any purpose whatsoever is confusing the method of discovery with the subject matter of discovery. Whether or not his cell phone needs to be collected and forensically copied and given over to the defendants is different than a textual description under a Rule 34 request of what is it that the defendants are looking to find? What is the information that they want? There's no allegation that he's never ever made a defamatory statement. There's no allegation on which anything could be based of what information is sought. So it's facially overbroad. It's the kind of thing that's just meant to conjure up and make a witness feel intimidated by thinking that all of his personal concerns, when his children text him on the phone with a problem at school or a very personal, hurtful, personal issue, that these are all going to be vetted in the public domain. So you should slap this down pretty firmly and reconstitute their request into a proper Rule 34 request, which identifies information that's the subject of discovery, not a cell phone. Thank you, Your Honor.
Thank you, Mr. Roberts. Ms. Cook?
Well, first, I'd like to argue that he wants us to dismiss the motion to compel the production of these cell phones, saying that there's not potentially relevant information, and that's clearly not true. At issue in this case is discrimination. That's the central issue. So communications that he had with his supervisors during the time of his employment that are contained on those phones would clearly be relevant and would clearly fall under the rules under 26B1. Under those rules, my client is permitted to obtain any non-privileged discovery related to a claim or defense. If you're arguing discrimination, communications with a supervisor would be central to defending that claim. And we need to see those communications so that we are able to defend that claim. And while we talk about proportionality, because we know that that's the baseline of any discovery, our request satisfies the proportionality. We have not received almost any discovery from the plaintiff, particularly text messages. And so when a court is able to order full inspection of devices when the other parties have been inconsistent or incomplete in their responses. And as we don't have really any discovery related from the plaintiff, I don't think that it would be inappropriate or disproportionate for us to have full inspection and copying of the phone. Further, we're willing to bear the cost for it, so it does not impose an undue burden or expense. And Mr. Dixon is the only person in possession of that phone. So it's not, we can't get access to it any other way. And it's not duplicative because we haven't received any other productions of his text messages or communications. And then in turn, go ahead.
And related to the motion to dismiss?
The motion to dismiss, I agree, it's under Rule 1. Rule 1, the court's command that you should, the whole purpose of the rules is to secure the just, speedy, and inexpensive determination of every action. Mr. Dixon just wants to keep on dragging out this case at undue cost, undue burden. There's no point in making the defendants keep in a counterclaim that's just going to cost more money and more time and more of a drain on the court's resources. It runs counter to the scope and purpose of the rules. The Rule 15 allows the court to allow us to amend our pleadings with the court's leave. The rule says you should freely leave when justice so requires. If Mr. Dixon is determined to delay and waste these resources to keep the claim in the complaint, then justice demands that our client should be permitted to dismiss, because we shouldn't have to keep litigating and relitigating and relitigating. Let's just get rid of these issues and then we can get to a final resolution of this case. And Rule 16b4 also allows this court to modify the schedule for things for good cause. And I think reducing the numbers of claims and costs and burden on the court would certainly qualify as good cause.
All right. Thank you, Ms. Cook. I'm going to pull these issues back up and make a ruling here. First, as to the plaintiff's need to produce the entirety of the cell phone for copy and inspection, the defendant's motion, the defendant's motion to compel the production of those for copy and searching and investigation of the phone in its entirety, I believe that request is too broad. I believe that there is a less intrusive way to get at the data in which is required here. So I'm going to deny that in part, but I am going to order that the plaintiff do produce all relevant text messages and any other relevant correspondence in conjunction with all other discovery requests within 15 days of the date of the order, so that we're ensured that defendant does get the timely copies of all those communications on the phone without subjecting the plaintiff to the undue burden of revealing non-relevant information, potentially privileged information, et cetera, that might be contained and is likely contained in those cell phones. As to the defendant's motion to dismiss, it's quite unusual to have a party object to the dismissal of a claim against them. However, I am going to deny the motion to dismiss the defamation claim simply on procedural grounds, in that I believe that this is an ask to amend the counterclaim, and I believe that that is untimely at this point, as the date for pleadings and amended pleadings has lapsed. And so I will deny that, and we will continue forward with the defamation claim and any corresponding discovery disputes related thereto at a different time. So thank you both for your time, and we will enter an order accordingly.
Thank you, Your Honor.
And for everyone who is joining in, thank you for joining. We did actually base our fact situation, our arguments on a few cases that I did want to cite. One was in the Northern District of Illinois. It was a case in which there was a defamation claim. Just pulling up some of the facts here. It was similar in nature in that there was a discovery dispute there. There was also a motion to dismiss made by the defendant. However, the time at which that motion was made came after much back and forth, many amended pleadings by both parties, and a gap of multiple years in time from the previous motion for amended pleadings. So that was denied on those grounds, similar grounds. And then the Santana case was a Kansas decision, recent decision in Kansas, in which the defendants had asked for all devices in which a plaintiff had related to not only communication with the supervisors, which was the fact pattern that we were basing our arguments on today, but with anyone at the company during, after employment with the company there. And the court ruled that that it was just too broad. There was too much information contained in the cell phone data, that plaintiff could provide that information, and had indeed provided substantially all of that information prior to the motion for the production of motion to compel for the production of the phones in their entirety via other portions of the discovery request that had been responded to by plaintiffs, and stated that indeed the plaintiff's actions and the request on behalf of the defendants did not give rise to the level where such failures or any failures alleged on behalf of the plaintiff gave rise to the point of obstruction or any other type of skepticism that the plaintiff was intentionally hiding data. So if you would like, we can certainly pass along copies of these cases, or feel free to, we can send the sites over and you can take a look at those as well. And with that, we will open it up if anyone has any questions, any situations that you've had that are similar that you'd like to discuss. We'd like to take a few minutes to hear from everyone else.
They may be muted.
Let me unmute the audience. All right, everyone is unmuted. So if you would like to join in the discussion, we're more than happy to have you.
I just wanted to say, Your Honor, that second basis that you denied the motion on, that was the second part of the argument. I just didn't get to it. The procedural thing, that was good. It was very good.
I did my research prior to the hearing as well.
Or as they say often, when the judge is arguing your case and winning, you just sit there. You don't need to help them out.
I guess I would be interested, and Chad, maybe you have a thought about when do you think full inspection would be allowed? That would be something I would wonder about. Like, in what context would that happen?
I can imagine, I think it happens more often in the criminal context, where it's more of a forensic need of, where has the phone been, and who may be other conspirators that we don't even know, that kind of thing. So I think probably the criminal context would be a case that way. And I'm trying to think of in a civil context and a fact pattern.
There was a similar case that was cited or at least referenced, in which a party had intentionally withheld some information, and there was skepticism on the opposing party side as well as in the mind of the court that that party was being forthcoming in not only their responses to discovery, but also in their responses to prior orders from the court related to their obligations for responses to discovery. And in that instance, there was one case in particular where the court did order a full copy of computers to be handed over to the opposing side for inspection. But that was a very isolated incident. There are others that are cited that don't give rise to that, even where there is some perceived bad acts by a party, in which there's not necessarily that level of skepticism in the minds of all else involved, that there's some intentional withholding. And I don't know if that ended up giving rise to sanctions or not, but I would think that if you get to that point, that there better not be much of anything found on there that you hadn't already turned over.
I think as a matter
might
of
be in a bit of trouble.
As a matter of personal experience, folks get into trouble because, let's say you lose that argument that you should have to collect things off your cell phone, and your client's kind of cranked about it, and maybe the lawyer's kind of cranked about it. And so that attitude of, I shouldn't have lost that hearing, there's really, this is, the other side's just bad and they're doing it for an improper purpose. That translates into the thoroughness and the integrity of your production from it, right? So you can have these episodes where it's just human nature that people will tend to be incomplete and not thorough when their heart's not in it. And so you can go from, I lost something, which is not only what's on my computer is discoverable, but what's on my cell phone is at least discoverable. You can go from just losing a little issue like that to having it blow up and the court lose confidence in the integrity of your production, and you lose control of your production. And maybe one middle road is, if I were being dragged down that path kicking and screaming, would be to at least try to punch out to a special master or a magistrate or a third party person who could at least be tasked with looking over all the sensitive things that are now going to be in the sunshine before they went to the defendant. And my client got shown all these things at depositions and stuff.
And I know in the law firm context, I've seen full copying when there's internal investigations by, say, the CEO or, you know, an employee they think is doing something a little bit sketchy on their cell phones, that they will just grab them and copy the whole thing. So I know I've seen it in that context.
Like as a preservation thing as well,
Yep.
almost. Yeah.
Yeah.
Yep.
Yeah, for preservation purposes, it's certainly you know, a much better idea to start with more and whittle down so that you have it. And actually, one of the issues that we didn't really talk about that was included in our fact pattern here was the data retention policy that Lockhart had. And one of the issues that resulted therefrom was they moved all of the data that they had for executives, particularly their Exchange email, to backup on a 6-month rotating basis, and only retained it for I think it was a 2-year period. And during the course of this litigation and related disputes, made a business decision to change vendors. And during the course of that vendor change, decided not to retain the things that had been held by the prior vendor, and not to take on the cost and time and headache associated with transferring data from vendor to vendor, which would be another interesting topic to discuss, in that they obviously were aware of litigation and preservation obligations, and yet someone either expressly made a determination that they didn't care, or was not properly notified or informed in a way to make the proper decision as to what needed to be retained for purposes of this litigation, or presumably others that would have been subject to a similar situation as those facts would lend themselves, and cause the defendants here a whole lot of headaches in a whole lot of places, particularly if they're involved in a lot of litigation that involves executive communication, which in my experience, if you're in litigation, you're going to have somebody that signs a check that has some knowledge of what's going on. So I think their communication would be pretty important.
I think this should be like the baseball toss at the carnival, where we just can't get out of here until somebody out in the audience, we have to get some questions just to get us released. Somebody's just got to volunteer. Folks I've never met. I don't know if there's a way they raise their hands in the chat room.
There is, but I do not see anyone
That's all right.
currently
That's
raising
all right. They're
their
just
hand.
out there. They're just out there torching us. That's all right. This also puts into play the you know, plaintiffs you know, crying the whole modifications now to the preservation rule and the potential for sanctions. And there's just not as much risk anymore in that kind of conduct that you described. The risk is a lot less.
All right. Well, we promised that we would try to keep this to a half an hour, and I think we were successful by about a minute. So with that, I would like to thank everyone for joining. We do plan to do this again in the future, and hope that you will we'll come back. If you have any questions in the interim, please don't hesitate to reach out. And if you have any topics that you would like covered, also feel free to send those along, and we'll be happy to take a look at them and address them next time. So again, thank you, Chad. Thank you, Amanda, for joining and playing along. It was a lot of fun, and thanks everyone else for joining, and hope to see you soon.